Folks, welcome to our webinar today. Today we're going to be talking about Idaho's new crisis hold statute. My name is Kim Stanger. I'm the head of Holland and Hart's Health Law Group and pleased to be here with you today. A couple of preliminary matters here. You should have received a link that will take you to some written materials, including a copy of the PowerPoint slides, but also a copy of the relevant statute, which is found at Idaho Code 56-2101. When the bill actually came out, it was labeled as 56-1901, but it's actually, when it was codified and put in the books, it's actually at 56-2101 at SEC. I've also provided you with a copy of an article that I did that pretty much summarizes everything that I'm going to talk about today. You can access that at that link, or you can get it through the link that Charles can send to you. I've also, because the crisis hold statute is related so much to Idaho consent statutes, I've also given you a link to an article I did on the general overview of Idaho's law concerning medical consents. And finally, I've provided you with a copy of a publication that DHW has actually put out. Hopefully Tiffany Robb won't get too upset with me that I made that available to you. I think it's available to all the hospitals out there, but it's another resource that kind of talks about these statutes. If you did not get the links or for those written materials, just email Charles at his address that I put in the chat box here, and he can make sure that he gets that information to you. All right, let's talk about a little bit of background for the new statute. For those of you who are at hospitals, you know for years and years and years, you've had this 24-hour mental hold that allows you to hold patients with a mental illness for 24 hours while you initiate court proceedings. Well, the problem is, a couple of years ago, well, for a long time, Department of Health and Welfare has said that that doesn't apply to non-psychological problems. And they clarified that a couple of years ago when they amended the statute to specifically say that the 24-hour hold statute does not apply to neurocognitive disorders. So what do you do about persons who show up for neurocognitive disorders? Is there anything that allows the police to even detain them or take them to a hospital? Or what does the hospital do with them once they show up? If they haven't got a psych problem, what can the hospital do? Well, this past year, the legislature passed a new statute that creates this crisis hold that allows the police or hospital to initiate this hold so that the hospital may provide temporary stabilizing care for that individual. Now, I'm going to step out of the new statute for a minute and give you kind of my thoughts about, is this new statute really even necessary? Does it really help that much? Because if you look at existing consent law, if the patient's competent, then obviously they have a right to consent to or refuse their own health care, and you generally have to follow what they say. You just want to document that the patient's competent under the standard in Idaho Code 39-4503, which basically says that the person understands and appreciates the consequences of what they're doing. If they are competent, then they can make their own health care decisions, including consenting to or refusing their own care. Now, if the patient is incompetent, or even if the patient is competent, most of the time the patient's not going to be competent, right? But if the patient is competent and they refuse their care, the statute would allow you to initiate a mental or crisis hold if the patient's gravely disabled or the patient's likely to injure themselves or others. But that's usually not the situation. You're usually dealing with patients that are incompetent. Okay, so let's say you got the patient that's incompetent. Well, even under existing law, if it's an emergency situation or the patient needs care, Idaho statute, as well as EMTALA, if you're at a hospital, would allow a healthcare provider to go ahead and render necessary care while you seek the surrogate's consent. Once you obtain the surrogate's consent, then that surrogate decision maker would have the right to consent to or refuse the care, and you could go ahead, if they consented to it, continue to provide care consistent with that surrogate's consent. If they refuse the care, then, generally they have that right to do that, and you would document it. If you thought that it constituted vulnerable adult abuse or maybe child neglect, then you could report that potential abuse. But I suppose you would also have the option to initiate a mental or crisis hold. I guess my point here is that in most situations, you really don't need the crisis hold because if a patient is brought in there with a neurocognitive disorder, if they're incompetent, you can generally go ahead and provide necessary care while you seek the surrogate and really don't need the crisis hold statute. Nevertheless, If you feel like you want it, maybe you want extra protection, or maybe you're looking for a payer source under the new statute, then you could go ahead and initiate this new crisis hold. Now, importantly, you've got two different statutory schemes now. If it's a mental situation, if the patient's mentally ill, then you'd go the mental hold route. On the other hand, if they've got a neurocognitive disorder, you would go the crisis hold route. Mentally ill, for purposes of a mental hold, means a condition resulting in a substantial disorder of thought, mood, perception, or orientation that grossly impairs judgment, behavior, or capacity to recognize and adapt to reality and requires care and treatment at a facility or through outpatient treatment. That's the definition in Idaho Code 66-317. And you could initiate the mental hold under 66-326. Importantly, as modified, that does not include a mental illness, does not include a neurological disorder, neurocognitive disorder, developmental disability, physical disability, or any medical disorder. Hence, we needed the new statute, or at least the legislature thought that we needed the new statute. Note that it only applies to neurocognitive disorders, not those other gaps created by the mental hold. It doesn't necessarily apply to a neurological disorder, developmental disability, physical disability, or any other medical disorder unless it's a neurocognitive disorder. Neurocognitive disorder is defined as decreased mental function due to a medical disease other than a psychiatric illness, including Alzheimer's, frontotemporal lobar degeneration, Lewy body dementia, vascular dementia, TBIs, HIV, prion disease, Parkinson's disease, or Huntington's disease. It specifically excludes decreased mental function due to substance abuse or medications. That would not constitute a neurocognitive disorder, at least under the crisis hold statute. If you look at 66-317, it actually defines neurocognitive disorder to include decreased mental functions due to substance abuse or medications, but when the legislature passed this, they did not extend the crisis hold statutes to substance abuse situations. It's important to look at the difference in purposes for the two different statutes. Under the mental hold statute, the purpose, it's been on the books forever, the purpose was really to allow the police to pick up somebody, bring him to the hospital, and or allow the hospital to hold the patient for evaluation by a designated health examiner. And if the health examiner thought that the person was mentally ill and substantial harm to themselves or others or gravely disabled, then to go ahead and initiate commitment proceedings. Those commitment proceedings are for a long-term disposition of the patient, right? It was so that if you go through that whole process and they're committed into the care and welfare of health and welfare. So it really was designed for a long-term solution for committing these people with mental illness. As a practical matter, quite often it would, the person's condition would resolve or at least stabilize while those whole court proceedings were going on. So, very few of them actually ended up in the actual commitment proceedings. But the whole goal was kind of to come up with a final solution or a permanent solution for committing these people into the state's custody. That is not the situation for the crisis hold statute. The whole purpose of the crisis hold statute was to allow the police to pick up people with a neurocognitive disorder, bring them to the hospital, and or allow the hospital to hold the person for a short, limited period of time, during which hopefully they would be able to stabilize the patient and return them to their other care setting. So it was, if you look at the purpose, it was to evaluate and address an acute crisis due to an underlying medical condition. Therefore, it does not provide a permanent solution. It only allows for a temporary hold while you try to stabilize the person. I'll come back to that in just a minute. So here's the process. Effective October 1st of this year, police may detain and take a person to a hospital, or a hospital healthcare provider may detain a person to receive medical care if they satisfy the following two criteria. That they have reason to believe that the person has a neurocognitive disorder under the definition we just talked about, and the person is likely to injure themselves or others. That means that they pose a substantial risk of serious physical harm will be inflicted by the person upon themselves, or they lack insight or unable or unwilling to comply with treatment such that the person will in the reasonably near future inflict serious harm on themselves or on others. That's the standard for initiating the crisis hold. If they satisfy that, then the police can pick them up, bring them to the hospital, and or the hospital personnel, hospital healthcare providers can go ahead and initiate that crisis hold. Now, if you hold that patient beyond 24 hours, you've either got to file a petition with the court to authorize continued care or continued holding that patient, or presumably you would need to obtain consent, if the patient's competent, from the patient or a surrogate decision maker. So this hold only applies for the 24-hour period. So after the 24-hour period, or within that 24 hours, you've got to go to court to get authorization to hold the person longer than that 24-hour period. Unless you get consent from the patient or you get consent from an authorized surrogate. Now, under the statute, upon taking a person into custody, a good faith effort must be made to provide notice to the person's legal guardian, parent, spouse, or adult next of kin of the person's physical whereabouts and reasons for taking the person into custody. Basically, let them know, hey, we've got your family member here to provide this care. The statute does not expressly say who's supposed to provide that notice, whether that's the police or the hospital. Presumably, it'll be devolved to the hospital to go ahead and track that down and provide the notice. But you may want to work that out with the police. Now, importantly, once you've notified that family, presumably the family is going to be the surrogate decision maker under the standards in 39-4504. And once that surrogate is notified, if they consent to continued care, there really is likely no need for continuing to hold at that point, unless maybe you want the payer source, because under Idaho Code 39-4504, if the patient's incompetent, then you'd look to the surrogate decision maker, and the surrogate decision maker can authorize the continued care. And as long as you've got that authorization for the continued care, you really don't need to involve the court, again, unless maybe you're looking for a payer source. So if the surrogate consents, you can go ahead and provide the care. If the surrogate refuses needed care, then, well, generally under the Idaho statute, they've got the right to do that. You would just want to document that they're refusing care. If you think that, again, it's inappropriate or it constitutes vulnerable adult neglect or child neglect, then you could always report them or contact the CPS or Adult Protective Services and report the situation without identifying the particular individuals involved. Ask them if it's reportable. If they say it's reportable, then go ahead and report it and let them step in and take the issue. I suppose you could initiate a crisis hold, but you've already done that, so that's probably not going to work at that particular point in time. Now, unlike the mental hold statute, the crisis hold statute expressly allows the hospital to terminate the crisis hold at any time, in which case the patient then just simply becomes a voluntary patient. So play this out. Patients brought in, the whole purpose of this statute is to allow the hospital to hold this person and provide stabilizing treatment. Once they're stabilized, then the statute allows the hospital to go ahead and terminate that at any point in the process. So the patient's just a regular patient, a voluntary patient at that particular point in time. There is nothing that requires you to go to the court to get that crisis hold removed. As a practical matter, though, if it's been more than 24 hours, so you've gone to the prosecutor and you've initiated court proceedings, you're probably going to want to let them know about it. Otherwise, they may not be very amused that they are continuing down this path after you've released the patient or determined there isn't a crisis hold, it's not appropriate anymore. But it does give the hospital that right at any time to terminate that judicial process or terminate the crisis hold. Now, if they terminate it, if they're going to continue to provide care, then obviously they need either the patient's consent if the patient's competent, or they would need the surrogate's consent. In addition, the statute expressly says that the hospital may, or there's nothing in the statute that prevents the hospital from transferring a person in a crisis hold situation to another hospital that's willing to accept the patient for purposes of observation, diagnosis, evaluation, care, or treatment. So if this patient shows up at a critical access hospital, you need to transfer them to some other facility with specialized care. There's nothing in the statute that prohibits you from doing so. Not clear exactly how that would apply to or correlate if there's an ongoing court case, you started that court case process and suddenly the patient's no longer around. So if you are going to transfer, you may want to touch base with the prosecutor to see how you're going to handle that. Obviously, before you transfer that patient, you still got to comply with other rules, including the patient consent principles. You can't just you can't willy-nilly send the patient wherever you want to unless you've got patient or surrogate consent. In addition, if it's an EMTALA situation, then the EMTALA transfer requirements are going to comply. You're going to have to satisfy that. This statute that allows the transfer doesn't void those other laws like that. What about minor consent issues? It's not real clear to what extent this statute applies to minors' consents. It doesn't exclude minors on it. But as you know, for those of you who've been dealing with the mental hold statute, prosecutors sometimes state that the mental hold statute doesn't apply to minors. Instead, you would look to the shelter care statute under Idaho Code 16-2411 if you're dealing with minors. Not real clear whether they'd take the same position under the crisis hold statute. The shelter care statute really applies to, emotional distress type situations with the minor, may not apply to neurocognitive disorders, so probably you're going to be okay if you issue that crisis hold for minors. But there's another statute out there right now, remember, because this legislature passed that new statute that effective July 1st, you generally have to have parental consent to provide care for minors, and providing care for the minors is any type of healthcare services and would presumably include the crisis hold situation too. So generally, if you're going to initiate a crisis hold, you got to get parental consent. The statute does allow you to go ahead and provide care for an unemancipated minor if you either have blanket consent, well, that's not going to apply very often in a crisis hold, or if it's a medical emergency and it's necessary to prevent, the care that you render is necessary to prevent the death or imminent irreparable injury to the minor child, or you cannot locate the parent and the minor child's life or health would be seriously endangered. Not real clear how that's going to apply, because a lot of the times when the patient's brought in, it may not be a medical emergency within the meaning of the crisis or the parental consent law, but we don't know. As a practical matter, you're probably going to be okay as long as soon as you get that patient, you reach out and try to contact the parents, but you're obligated to do that anyway, right? Reasonable steps have to be taken to notify the parents on that. So in the case of minors, you're generally going to want to seek parental consent or get a court order that would allow you to provide that care. Otherwise, you may run afoul not only of the crisis hold statute, but the new parental consent law. Okay, so you've got that patient and you're going to hold them for longer than 24 hours. You got to go through the judicial procedure. Under that procedure, someone has to notify the court and seek a court order allowing a temporary hold, and you've got to do that within 24 hours of initiating the crisis hold. This, unlike the mental hold statute, the statute does not say who is responsible for initiating that. As a practical matter, I assume it's going to be the local prosecutor who would file that with the court, but you as a hospital would probably want to check with the local prosecutor's office to make sure that that's the case. If the court agrees with that, the court may order a temporary hold and evaluation by a hospital provider. That can be really any appropriate hospital provider. Presumably it'd be a physician or an NP or a PA who were qualified to do the evaluation to determine whether or not that patient truly does have a neurocognitive disorder such that they're going to likely to harm themselves or others. The statute does not expressly allow or address providing medical care in the meantime, right? Even though that's the whole purpose of it. So if you are going to go for that kind of order, you may want to have that expressly put in the order that you get from the court. So it not only authorizes you to hold the patient while you do this further evaluation, but also to provide necessary care in the meantime. Unless, of course, you've got effective consent from the surrogate or a competent patient, in which case you really don't need the crisis hold anyway. Once that report is done, the provider reports the court findings to the court within 24 hours. If the exam concludes that the person no longer meets the criteria for crisis hold, then the patient's going to go ahead and be treated as a voluntary patient and the crisis hold would end. But that doesn't mean you can just ship them out of the hospital. They're still your patient, and therefore you got to comply with whatever requirements still apply, whether it's malpractice, discharge instructions, or whatever, or EMTALA requirements. If the person meets the crisis criteria for the crisis hold, then the prosecutor, you'd have to go back to the prosecutor, let them know, and the prosecutor files a petition to continue a hold pending a protective placement hearing per separate statute, Idaho Code 56-2105. This particular hold process states that within 5 days, the court has to have a hearing to determine whether or not they're going to authorize that continued stay. But here's the kicker. Even if you go through that whole process and you have that hearing, at most, at the end of that hearing, the court can only order the protective custody at the hospital for observation, care, and treatment for up to 7 days. So you go through that whole judicial process, and at most you just have a week, right? At the end of that whole process. It's a lot of rigmarole to go through that whole process only to get another week. Like I said, this does not provide for any kind of temporary solution or any permanent solution or permanent placement of the patient. At most, you're going to get up to 7 days. But before you ever get to that hearing, you're probably going to have contacted the surrogates and probably have surrogate authority to go ahead and hold the patient, so the crisis hold situation would never continue anyway. But nevertheless, there you go. The crisis hold procedures will allow the hospital to obtain payment under certain circumstances, like we'll talk about in a minute. So maybe that's why you want to go the court route, but nevertheless, that's the way that works. There is a separate process. You kind of have the judicial process that if you just initiate the 24-hour hold process that you go through that we just talked about. There's a separate process under 56-2104 that would allow family members or a prosecutor or hospital personnel or a facility administrator to go ahead and initiate on their own temporary placement proceeding. And there's a whole process for doing that. I'm assuming not many of you are going to go that route. Really no reason to go that route if you're just a hospital that received them, and you can go by the other process. But nevertheless, there's this other process out there. And it talks about the hearing, the deadlines and everything that you need to do there. The important thing is that, again, even at the end of that hearing, the court can only order the detention for up to 7 days. So hopefully you've stabilized the patient before then, and it never gets to the time that the court has to make that determination anyway. It's not really clear how this separate administrative procedure fits with the hearing under the other statute. It looks like that once you get to the point where the court's going to order the hearing, then you'd switch over to this statute in 56-2105, but it doesn't fit really well, and just let you know that there are some uncertainties there. All right, so at most, even if you jump through all those hoops and you haven't found the surrogate to consent to care or insist on going the crisis care route, at the end of the hearing, at most, the court can only order continued care for up to 7 days. Well, that begs the question, then what happens at the end of the 7 days? If the patient's still not ready for discharge at that time, do you obtain consent from a patient or personal rep for continued hospital care? Well, yeah, I guess you can, and that'd probably be okay. Do you return them to a facility or their prior care setting? Yeah, I mean, that's optimal. That's what you're supposed to do. But, what happens if the patient has nowhere else to go? Which is the problem, sadly, that a lot of our Idaho hospitals are dealing with right now. And the statute really doesn't address those situations. The court order only allows you to hold that patient for up to 7 days, but at the end of the 7 days, I mean, are you left hanging? What can you do? Presumably, at the end of those 7 days, you would have obtained consent from an authorized surrogate that would allow you to go ahead and hold the patient or identify some other means for holding the patient. Can you just simply send the patient home at the end of those 7 days? Well, probably not, without potentially running afoul of obligations you may have under either medical malpractice, maybe discharge instructions or discharge standards. If you're a hospital or critical access hospital, the bottom line is this statute does not solve the problem for those patients who've, you end up boarding for a long period of time. To address those situations, I actually did a whole program on that. You can go to the website that's listed there, that link, and it'll take you to a whole program I did talking about some of those options for dealing with these patients at the end of that 7-day period, or when they're just refused or to leave the facility, or you can't find another place to send them to. As I mentioned, maybe one of the real reasons to do the crisis hold is to secure a payer source. The statute sets forth a structure for payments for crisis holds. The cost of the hold itself, separate and apart from routine medical care that may be necessary for the patient. The statute says that that's the patient's generally responsible for that, subject to DHW's determination of the patient's ability to pay. The DHW is supposed to report findings to the court, and presumably you would get a court order through that hearing process that requires the patient to pay. Of course, that assumes you've gotten the court process. If you terminate that without going to court or without getting that court order, it may be a little bit more problematic to try to get payment from the patient. Well, as far as the routine medical care that you're providing there, because remember the whole purpose was these patients had some kind of medical issue in addition to their neurocognitive disorder, so you're trying to stabilize them. The statute says that the patient's insurer, including Medicaid, is primarily responsible for the care or the costs of that routine medical care. The statute specifically allows third parties, which could be a hospital person, to apply for Medicaid on behalf of the patient so that you can get a payer source to help cover it. If there's a gap left after applying the patient's insurer, then the statute has a process for apportioning those costs between health and welfare and the patient. The crisis hold statute also has quarterly reporting requirements. This will help the legislature as they evaluate the efficacy, the need for crisis holds, and what else needs to be done in these situations. If you're hospitals and you're running into these situations where you're ending up becoming a hotel for people with neurocognitive disorders or others who are just dumped at the hospital, you'll probably want to do these reports and give the legislature some data so that they can address these issues in the future. So, in summary, this is my quick and down and dirty how you apply this. If the patient shows up and they're competent, generally you rely on the document the patient's or the resident's consent or refusal, unless the patient fits the criteria for a mental hold or crisis hold. In that situation, then you could go ahead and initiate the crisis hold, but that doesn't happen very often. Usually the patients who are brought in are incompetent. So if the patient's incompetent, then the statute already, without the crisis hold, allows you to provide needed emergent care consistent with the patient's prior expressed wishes. That's under both the Idaho statute as well as if you're at a hospital, EMTALA would allow you or require you to go ahead and provide that care. You'd provide that care while you seek consent from a surrogate. Once you get that consent from the surrogate, if they authorize continued care, you really don't need the crisis hold because you've got the consent you need in order to continue to care for the patient. If the surrogate refuses care and you think that you need to initiate the hold, then so be it. You can go ahead and do it if you satisfy the criteria for either a crisis hold or a mental hold, depending on whether it's a neurocognitive disorder or a mental hold. All right, for other resources, as I mentioned, Tiffany Robb has been spearheading this on behalf of Department of Health and Welfare. I understand that she sent out a brochure or a booklet to hospitals explaining this new protective placement custody. If you want a copy of that, I've made it available, but you can contact Tiffany Robb if you've got questions. That brochure has kind of a summary, at least from DHW's perspective. It has a flow chart. It has there's some links that Tiffany's made available from 80 county prosecutors that have developed forms that you might be able to use in working with your own prosecutors. And it's got the state is also in the process of doing statewide training programs. I think that there's 3 of them that are scheduled, but if you want more information about that, if you don't have it, Tiffany Robb can provide that information for you. Or you can go to our website and we've posted some information, including those articles about crisis hold. That's it. Pretty short one today. If you have any questions about any of this stuff, feel free to use the chat feature. You can submit those via the chat and I'll get those and respond offline. Or you can just go ahead and shoot me an email and I'll respond offline. Good luck with this. As we work through these issues, I know the legislature is trying to tweak it and perhaps fix it. To that end, you might reach out to Tiffany to explain the concerns that you got with that. All right. Thank you very much. Hope you all have a good week.